Hey everybody, Kate Miller here, coming to you on my latest Zoom session with my favorite male attorney. Just kidding, Brett Holladay. Hey Brett, how are you today?
Good morning. Doing well. How you doing?
Good, good, good. Thanks. So, Brett, we have a ton of cases from the Court of Appeals that have come out this year, and one that I thought was really important for folks to understand was the Ward v. Halperin case, which actually is a Mecklenburg County case that went up to the Court of Appeals. There were trials in this case anywhere between 2016, 2018, 2019, and then father appealed the decision that Judge Blake issued, and the Court of Appeals came out with their decision just this month. So tell us about it. Tell us about Ward v. Halperin.
Yeah, sure. So this was I think anyone in the case would agree, was a high conflict custody case. You had a mother and a father who had a 50-50 custody arrangement. Some issues came up. They brought some modification motions before the court. And what they had before was a 50-50. And what the court did once they modified the order was to say mom is going to have primary physical custody moving forward, but that also mom was going to have, or the parties were going to split decision-making, joint legal custody, but that mom would have the final say on major issues if they couldn't reach a decision together. So basically, try to talk things out, but hey, if you can't agree, mom, you're gonna make these final decisions. So dad wasn't happy with that, as you know, is often the case. One party walks out or not happy. So dad goes to the Court of Appeals and says, I'm appealing whether mom should have the right to have final say. And he also appealed the attorney's fees that were awarded to the mother. And so what the Court of Appeals did on appeal is the majority opinion approved the judge, and this was Judge Blake out of Mecklenburg County. They approved her decision on both points. There was a dissent in the case, and they disagreed on both of those points. But what the majority said is look, the court found that, while these parties should make decisions together, if they can't make them together, then mom, does have the right to make them on her own. We felt that there were sufficient facts for that. The dad said that there weren't sufficient facts. They said, no, there were facts in the record. Even though there was high conflict, mom was maybe more tentative to the kids' needs. She was more involved in their lives, and that's why the court was able to make that decision. The dissent basically said, no, I still think you need more facts to really take away that power from a parent. And so, but what matters the most at the end of the day is the majority says, yep, we approved the order. And so the order is good to go there. On attorney's fees, the father basically said he didn't think that, mom should get attorney's fees. The majority opinion said, hey, you didn't really challenge the facts of the underlying order, and so we're kind of stuck with them, and therefore we think they were sufficient. Whereas the dissent said, hold up, we still don't think that that's enough, because the court didn't get into an analysis of whether the mom had the ability or inability to pay her attorney's fees. And what's important there for parties going to court is that you have to show that you brought your claim in good faith, which is typically the easier part of the analysis for attorney's fees, but also that you don't have the ability to cover those fees yourself. That doesn't mean you don't have any money. It just means that, a lot of times what the court will say is that you shouldn't have to deplete your estate to go to trial. And so the dissent in this case said, look, mom had gotten a lot of money from her family. $150,000 in gift money from her family. So how are you saying that wasn't enough? But apparently in the court and the majority's view, that was fine. She could, still get that type of gift money and still get attorney's fees back. And I think what it really brings out, a good point for people thinking about appealing a case, is that, even if you appeal a case, you got to think about what comes even after you win, so to speak, because mom's decision was clearly upheld here. Yeah, exactly. And so dad, he appeals it and says, I don't like either of these things. Well, in any event, even if the dissent had prevailed here, the dissent still said, hey, send it back to the trial court. And we're going to let them make further findings, which, with a competent judge, they're just going to take the same case and craft the same result. They're just going to draft the order a little bit better. And so you really have to kind of think about the long game with some of these. And and really whether it's worth it to you. Clearly the dad thought it was here, but that's always something a client needs to be considering before they're moving forward with an appeal.
Absolutely. Great advice, Brett. Okay. Well, Ward v. Halperin, 2020 case from the Court of Appeals. Lots to chew and think about. So I appreciate the analysis, Brett. Thanks for joining me today.
Absolutely.
All right.